We're going to look at the organizational chart of the judicial system. We have a dual court system, and that is the federal courts and the state courts. And so this is just the organizational chart for the federal court system, except for right here we have the highest state court, which is in Indiana. That would be your Indiana State Supreme Court. So we'll talk about that briefly. The Supreme Court has both original and appellate jurisdiction. The appeals courts here, including the Indiana State Supreme Court, these all have appellate jurisdiction. And then these down here would have original jurisdiction. So they're going to hear the cases for the first time. An injured party who feels like the lower court ruled it wrong will appeal to a higher court, and then the only place to go after these Court of Appeals is to the United States Supreme Court. And there are a few things that they can hear firsthand with original jurisdiction. The rest of it they have to hear on appeal. All of these lower courts down here, except for the Indiana State Court, was created by Congress. They are considered, well, let me stop myself right there. You have what are called constitutional courts and legislative courts. Your constitutional courts are the ones where your justices serve for life and you can't change their pay. Legislative courts, their judges serve for a fixed term and their pay can be manipulated. And I'm just going to point out the three legislative courts, the military courts, the U.S. tax court, and then the territorial courts. The rest of these are your district courts. Those are your 94 that are divided up amongst all the states that actually hear the court cases. And then these over here are also constitutional courts. So these are the ones, again, that will serve for life and you can't manipulate their pay. So constitutional courts serve for life. And I don't anticipate you seeing a question like that. I think I've seen just a couple that refer to constitutional courts versus legislative courts. But if you'll notice, military, U.S. tax, and the territories, which are Washington, D.C., America Samoa, the U.S. Virgin Islands, Guam, they're very specific in what they're dealing with. The rest of them deal with a lot of different types of cases. So they're very specific in the types, and they're just legislative courts. The district courts, we talked about senatorial courtesy. Those are the courts that you're going to see. Again, there are 94 of them. All of these courts, if they want to appeal their case to a higher court, they're going to go to the United States Appeals Court. And I think that's about it. Let me check my notes real quick. Oh, no, I definitely do want to talk a little bit about on this dual court system. Some cases can be heard in either court. And when I talk about either court, I mean whether a federal court or a state court. Some cases can, and it's based on the subject matter. I'm more concerned about the idea that some cases can be tried twice. You can be tried if you break a law in both federal court and state court, and it's not considered to be double jeopardy. Each level of government has the right to enact laws to serve its own purpose. And neither level of government, whether it's federal or state, want to block the prosecution of an accused person who has sympathy of the authorities at one level. And this kind of goes back to when you would have situations at the state level in the South where you would have an all-white jury and they would not prosecute, or they would find not guilty someone who was accused of harming someone who was black. And so that happened at the state level, but then this person could be tried at the federal level, get it out of that state court, and then they can be held responsible for their actions. And so that would not be considered double jeopardy.